What's up? We have quite. This is fucking tight. Let's pull that down a little bit. How's everyone doing tonight? Today, not tonight. Today, it's 4:09. I am 9 minutes late, but there's some interesting shit going on the Senate floor right now that I think, Leader Thune is trying to get the suppressor stuff back in the big beautiful bill. I could not catch what they were talking about at the beginning. But they were arguing over parliamentary shit, and that's the thing that really screwed the suppressor stuff out of it. Let's see if I can find it on Twitter. How is everyone doing? Zero, how are you doing? Bruce Wayne, what's up? Anyone else lurking? How are y'all doing today? It's Sunday. I'm so close to vacation. I have the 3rd and the 7th off, split by a nice long weekend because of Independence Day, and then the 8th is our big firm-wide meeting, so it's also technically a day off. So I'm honestly any work day that I can wake up at like 9 o'clock is a day off for me. Let me see. Senate. Right. Okay. So this is what's up, Marianne? One of the things that they tried to strip out of the big beautiful bill was healthcare funding for illegals. Hang on, barring taxpayer-funded healthcare for illegals. So that was in the bill, and then along with removing the suppressor stuff from the NFTA and I forget what else. There's short barrel rifles. And a Senate parliamentarian removed them, claiming that they violated the Byrd Act. The taxpayer or the barring of taxpayer-funded healthcare has been added back to the big beautiful bill. So there's a win. There's a win right there. Okay, should we just get into it? What do y'all think? Okay, this is how we're going to do this. Open link in new tab. I'll tell y'all what, the SCOTUS blog is really good because while you get kind of a, in some cases, bullshit article about what the justices said, what their dissenting opinion says, all that kind of stuff, you can still go down to the bottom of the page. And here, I'll show y'all here. You can still go down to the bottom of the blog post and see what the case is. And when you click on it, you can see all that stuff. So you can then read the opinion yourself if you're so desired. But I'm opening all of these, and I probably should have opened them a while ago. But Okay, so we got several cases here. Let's go with this one. Are they all going to be the same decision? They should be. They should have been combined into one case. Barrett. Yeah, they are. Yeah, they're consolidated with each other, so they should all have the same the same opinion answer. Let's see. What's up, Margaret Riggle? How are you doing? Or I mean, how you doing? Let's see. Oh, Gun Control Act. This would be one nice one. When was this decided? March of this year. Okay, I don't really care about that one. Sitting, nope. Don't care about case name or sitting. Oh, I can only do those two. Let's see. They must have put Richard Jordan to death. Okay, let's start. Which one do we want to start with first, guys? Do we want to start with the injunctions case, the gay books case, or I actually don't think I have that one open. No, yeah, it's right here. Or the non-citizens expulsion case. I'm leaving it up to y'all. Zero. Yes is not the correct answer in this case. I need a decision. Come on. You all know which one you want to start with. Okay, we'll start with that one. Give me 1 second to. I want to tweet this real quick and just be like, "Hey, we're live now." Where? That's because I'm on King's Court over here on YouTube. Ooh, I don't want to hear my voice. Okay. 1 second, guys. Yeah, I really should have done this earlier. Okay, here we go. Let's get the gi out of the way. So this is the case, Mahmoud v. Taylor. So let's pull up the decision. I'm going to bring it up over here. I'm going to split it on my main monitor. I got a lot of shit open on my computer. Don't save. Let's exit that. Don't save. And everyone, don't forget. Isn't that fun? Okay, so let's share this tab instead. In the Supreme Court of the United States, in Mahmoud v. Taylor. Mahmoud, right? That's how you would say that. Coming out of, is this out of Alabama? No, the Montgomery County Public Schools in Maryland. So in November of 22, the Montgomery County Public School System added LGBTQ plus inclusive children's books to its language arts curriculum for pre-K through 5th grade. Initially, parents were notified and could opt their children out. But in March of 2023, the school board eliminated the opt-out ability. So a diverse group of parents, including Muslim, Catholic, and Ukrainian Orthodox family, that's Eastern Orthodox, sued the school board and Superintendent Thomas Taylor, arguing that the no opt-out policy violated their First Amendment rights. Seems pretty obvious to me. Let's see. The lead plaintiffs were Tamir Mahmoud and Enos Barakat, joined by other parents and the group Kids First. So they wanted an injunction to restore the opt-out policy. So let's see. When parents in Montgomery County sought to have their children excused from instruction involving those books, the board initially compromised with the parents by notifying them when the books would be taught and permitted their children to be excused from the instruction. That compromise was consistent with the board's guidelines for respecting religious diversity, which professed a commitment to making reasonable accommodations for the religious beliefs and practices of students. Less than a year after the board introduced the books, hang on, I don't like that it's not zooming in like in the middle of the thing. There we go. That's a bit better. Y'all probably read along a little bit better now. See. Less than a year after the board introduced the books, however, it rescinded the parental opt-out policy. Among other things, the board said that it could, quote, could not accommodate the growing number of opt-outs requested without causing significant disruption to the classroom environment. So clearly the amount of kids whose parents were saying, no, we don't want our kids hearing this stuff. And remember, guys, this isn't 7th, 8th, 9th graders. These aren't kids that probably already know what most of this stuff is. Because, you know, let's remember when we were kids, okay? And we'd go watch a movie like, The Hangover. I remember seeing The Hangover for the first time when I was in 9th grade. Does that track? When did The Hangover come out? 2009. That would put me, depending on what time of the year it came out, either 9th or 10th grade. So, sorry, either 8th or 9th grade. When did it come out? It came out in June. So I probably watched it when I was in 9th grade. Okay. There's a lot of adult jokes in that movie, but I already knew what those jokes were. So for a 9th, 10th, 11th, 12th, yada, 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 for kids that age, high schoolers, I should say, this stuff isn't, in my opinion, that big a deal because they already know what it is. They already know what all these, for most of them, probably already know. I'm sure there's one or two that don't know, and the parents want to keep it that way. So having an opt-out ability is fine, and I agree with that. You know, a parent, it is a parent's right to determine what education their kids receive. The petitioners here are a group of individual parents and an unincorporated association of other interested parties. The individuals' parents come from diverse religious backgrounds and hold sincere views on sexuality and gender, yada, 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 yada. I don't really care about all this. Held that parents challenging the board's introduction of the LGBTQ plus inclusive storybooks, along with its decision to withhold opt-outs, are entitled to a preliminary injunction, meaning that the families, the plaintiffs in this case, are allowed to receive an injunction to force the school board to restore the opt-out policy. So the history of this case is that the district court, the U.S. District Court for the District of Maryland denied the injunction in August of 2023, stating that the parents' claims of indoctrination did not establish a free exercise violation. The Fourth Circuit Court of Appeals, that's up in Richmond, Virginia, upheld this decision in May of 24, ruling that mere exposure to differing views did not constitute coercion. The parents appealed to the Supreme Court, which agreed to hear the case in January of 25, and oral arguments occurred on April 22nd. So, let's see. I don't really want to go into the cases that they're going to be citing. Who wrote this? That's what I need to see. I need to see who wrote this decision. So this is Mahmoud Alito. And this was 6-3, and I guess who the dissenting judges were. Does it tell me who? Well, so this is actually interesting. All right, so they whew, that'll wake you up. So the Supreme Court agreed to hear the case in January of this year. Okay. This is something we're going to do. And I'm going to be honest with everybody. If it starts getting into an area that I don't want it to get into, I'm going to stop doing it. But I want to look at who filed amicus briefs. Now, amicus briefs are briefs that friends of the court may file, basically trying to persuade the justices. So, what is advancing American freedom? Advancing American freedom. And you know what? We're going to use Grok for this. Let's see. Tell me about the organization Advancing American Freedom. I agree, Margaret. Just leave our babies alone. It's getting sickening. Founded in April 2021 by former Vice President Mike Pence, based in Indianapolis, Indiana. AAF claims to promote conservative values and policy proposals, building on the policy of the Trump-Pence administration. So it puts Trump in its thing. Its mission focuses on advancing economic prosperity, religious liberty, and national strength while opposing what it describes as the radical left's agenda. Okay, so now another amicus brief was filed by who is Professor S. Ernie Walton. I wonder if he's a member of the Walton family. I mean, if you're important enough to file an amicus brief with your name, is the interim dean, associate dean of administration and admissions, and assistant professor at Regent University School of Law in Virginia Beach, Virginia. He also serves as the faculty director for the Center for Global Justice. Oh, this is going to be bad, isn't it? His academic focus includes national security law, international law, and constitutional issues, with publications such as, quote, The Fundamental Right to Homeschool, a historical response to Professor Bartholet, and Gender Identity Ideology, the totalitarian, unconstitutional takeover of Americans' public school. Interesting. Okay. The Mormon Church filed an amicus brief. Let's see. Let's see. It looks like West Virginia filed one. Protect the First Foundation, NC Values, America's Future, America's First Legal Foundation, and the parents of Nicholas Brown. Wow, 66 members of Congress filed an amicus brief. Let's look at this. What's up, Andy? What's up, Hokies? How are y'all? Okay. We already talked about this. They say Title IX does not require the board's unconstitutional policy. So the board's policy was that we would like to allow you to take your kids out of the lessons, but there's so many of them now that's disrupting the school. And so their claim is that Title IX does not require the board to do that. Who are the signers? Bill Cassidy, Sanders, Cassidy, Banks, Blackburn, Budd, Cruz, Daines, Grassley, Hawley, Justice, Langford, Lee, Moody, Mullen, Ricketts, Tim Scott of South Carolina, Sheehy, Tuberville, and Wicker. And representatives, Adderholt, Scalise, Allen, Arrington, Babin, Biggs, Breachin, Cloud, Clyde, Davidson, Downing, Elsie, Fleischman, Fox, Gill, Gooden, whole lot of them. Anyone interesting? Nope. Okay, let's go back to this. Yes, that's the obvious remedy. Zero. That is an excellent point. So on June 27th, which was Friday, actually, the Supreme Court ruled 6-3 in favor of the parents, reversing the lower court's decision. Justice Alito, writing for the majority, held that the school board's policy substantially burdened the parents' right to direct their children's religious upbringing. All right, let's get to their kind of summary at the end. Actually, first off, who wants to go through what we see in the books? So this is Sotomayor's dissent. Okay, so she's about to bring up a book. Today's ruling threatens the very essence of public education. The court, in effect, constitutionalized a parental veto power over curricular choices long left to the democratic process and local administrators. That decision guts our free exercise precedent and strikes at the core premise of public schools, that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. Exposure to new ideas has always been a vital part of that project until now. The reverberations of the court's error will be felt, I fear, for generations. Unable to condone that grave misjudgment, I dissent. Here's the problem with this shit, okay? She's fucking right. She is 100% right about this. That public schools, college, high school, middle school, even fucking elementary school is a place for kids to show up and learn about the different shit in the world. Okay. Now, at what level they should learn and how much of that different shit should change by the level of schooling. But the problem is that it's not differing opinions, different ideas and stuff. It's one group's opinion and one group's opinion of the world that they want in schools. They don't want me to be able to walk in and teach a bunch of third graders about Jesus Christ and the Bible and how he died for our sins. They only want gay people and bisexuals and all this other sexual crap to come in and teach them about what they should be doing. That's the only thing they want in these schools. So this is the book that Sotomayor puts in. She says that this book is being taken out of schools now. And so let's look at it real quick. Uncle Bobby's Wedding. I gotta be careful because this author will probably strike me if I read it. Favorite uncle, took her on the river. They went to a lighthouse. So they went to a. Are those beers? Who cares? They had a picnic. They got rhubarb pie. Her uncles are getting married. Okay. I mean, so the problem here is that Sotomayor has picked one of the more, at least so far, it could get worse, but one of the more innocuous books that they have put in schools. But we can go, and we've all seen the videos of parents going to these PTA or whatever meetings, school board meetings, and reading the material that they've started putting in schools. And this is far and away the least objectivable book that I've heard. Well, I see. I'm kind of breezing through it because I don't want the author to be able to claim some BS. Okay. All right. So that's the. So that's what they're. And honestly, if I was the author, I would argue that she's broken my copyright by putting it in the thing. Let's see. Margaret says there was a time when sex education being taught in health class was an argument, but this goes way too far. The most risque thing in my high school library was the naked lunch. I don't even know what the naked lunch is. Margaret, I completely agree. I'm pretty sure I had sex ed in school. No, you know what? I actually missed sex ed. That's what was so funny. So I switched middle schools from 7th grade to 8th grade. And in my 7th grade middle school, sex ed was 8th grade. And in my 8th grade middle school, sex ed was 7th grade. So I actually missed sex ed. I did health class. So like I knew, I knew how everything worked, what where and all that shit. I didn't need a class for it. What I didn't need was a class full of a bunch of, 12-year-old kids going, I didn't need that. It was just a waste of my time. Hokies, the fact that you're censoring yourself in this makes it even funnier. Let's see. So the Sotomayor's dissent. I wonder if Jackson did a dissent as well. God, she wrote quite the dissent. Holy shit, I think she wrote a longer dissent than the fucking deciding opinion. Kagan and Jackson join in dissenting. Let's see what she says here. Public schools, this court has said, are, quote, at once the symbol of our democracy and the most pervasive means of promoting our common destiny. They offer, okay, so this is the other thing I want to do. Okay, so she cited Edwards v. Gillard. Let's see if this is still good case law. It was decided by the Rehnquist Court. So this case that she's citing, a Louisiana law entitled "The Balanced Treatment of Creation Science and Evolution Science in Public Schools and Public School Instruction Act," prohibited the teachings of the theory of evolution in the public schools unless the instruction was accompanied by the teaching of creation science, a biblical belief that advanced forms of life abruptly appeared on Earth. The question was, did the Louisiana law, which mandated the teaching of creation science along with the theory of evolution, violate the Establishment Clause of the First Amendment? And the court, in a 7-2 decision, said yes, it did. And Rehnquist and Scalia said no, it did not. But this is the problem. Well, wait, first, I want to see if this case is still good. Because that would be just like Sotomayor to cite a case that's no longer good. Okay, yeah. So Edwards v. Aguilar is still binding law. This is a concurring opinion from Justice Thomas. And this is the opinion of the court. Okay, so the board's introduction of the LGBTQ plus inclusive storybooks, along with its decision to withhold opt-outs, places an unconstitutional. What's up, Jay? How you doing, man? Places an unconstitutional burden. Where was I? On the parents' rights to the free exercise of their religion. The parents have therefore shown that they are likely to succeed in their free exercise claims. Again, so this is, don't forget that they're not, the Supreme Court's not deciding that the books can't be in there, or that the parents can exclude all this stuff. They're deciding that the lower court, the district court, the trial court, basically erred in their decision. They are remanding it back to the lower courts to be reheard. That's why it says they're likely to succeed in their free exercise claims. They're basically telling the lower court, hey, this is the outline you have to use when deciding this case now. What's up, Stephen Brown? What's up, Debbie, the girl from the land down under? They have likewise shown entitlement to a preliminary injunction pending the completion of this lawsuit, meaning that until this lawsuit is finalized, until the district court makes a new ruling, the school district is prohibited from stopping the opt-outs. In the absence of an injunction, the parents will continue to be put to a choice: either risk their child's exposure to burdensome instruction or pay substantial sums for alternative education services. Let's see. In light of the strong showing made by the parents here and the lack of compelling interest supporting the board's policies, an injunction is both equitable and in the public interest. The petitioners should receive preliminary relief while the lawsuit proceeds. Specifically, until all appellate review in this case is completed, the board should be ordered to notify them in advance whenever one of the books in question or any other similar book is to be used in any way, and to allow them to have their children excused from that instruction. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceeding consistent with this opinion. So these are the books they're talking about. This book, this is the one that Sotomayor cites in her dissent. So is this the same? Yeah, that's that same book. This is a different one. Some may be confused that a kid like me can wear what I want and be proud and carefree. My friends defend my choices and place a bathroom like all rooms should be a safe space. So okay, yeah, we got a equal bathroom there. These are book notes from that book. Sex and gender are related, but they are not the same. A person's sex refers to having male or female or intersex, both male and female body parts. Gender is something people show or do. That's a lie. It's not true. It's complete bullshit. Something they made up like 5 years ago that no one had the balls to actually sit there and go, "Are you fucking dumb?" A hijab is a. Why are we talking about what a hijab is? A hijab can stand both for female empowerment and respect for religious beliefs. Well, that's just not true. People deserve to be safe no matter what they wear. Through social movements like #MeToo and Time's Up, many women, and some others too, are using their experience to explain the importance of having consent or permission before touching another person. What's up, KC? How you doing? Let's see. So I'm guessing this book was some sort of, here's what all the different universal movements have been. Let's see. Here's another one. And on the two men's wedding day, the air filled with cheers and laughter, for the prince and his shining knight would live happily ever after. I guess. Okay. Oh, Mama gets quiet. I love you, Mama, but I don't want to be you. I want to be Papa. I don't want tomorrow to come because tomorrow I'll look like you. Please help me, Mama. Help me be a boy. Holy shit. Make a plan to tell everyone we love. Holy shit. This is terrible. Holy. Okay. Calm down, Caleb. Don't flip out too much. I don't understand how people can think 5-year-olds reading these books are a good idea. I don't think 20-year-olds, I don't think these books exist. I'm sure that's going to get me kicked off YouTube. Mark Reality says, and this is the sick shit they want to force your kids when you're not looking. Exactly. Yeah, exactly, Zero. Bad Parenting, the book. So that is the decision in Mahmoud v. Taylor. Don't forget, like I said about 20 minutes ago, this case does not remove the books. It does not say that the books cannot happen. It is simply telling the county, the Montgomery County School Board, that they have to allow opt-outs until the lower court has decided the case. Now, that doesn't mean that the lower court is going to decide for the plaintiffs. They could still decide for the board. But if that happens, I do imagine this gets back to the Supreme Court rather quickly, especially considering the last sentence or the last bit of the decision saying, let's see. Where was it? Was it up at the beginning? It might have been. It might have been. Hang on, let me go back up there. I don't know where it is, but it does say that the court does believe that the parents will succeed on the merits. So if the Supreme Court says we think the parents are going to win, and then the lower court says you lose, I would imagine that this gets kicked back to the Supreme Court rather quickly. Margaret Alex says, have you noticed that the left's new boogeyman word, gooner, is eerily close to the word groomer? Well, it doesn't surprise me. Okay, so that is that case. That was, no, I don't want to have a free trial, you dumb bitch. That was Mahmoud. Let's see where they are in the Senate. What are we doing now? Rand Paul is speaking. Let's see. I don't know who this was. They're still debating this bill. The problem is, even if they vote on this bill today, it still has to go back to the House because they've made changes to it. Which one is this? Oh, this is the, okay. Okay, next case, guys. Trump, President of the United States, and all v. Casa Incorporated. This is the case that is compiled with Trump v. Washington and Trump v. New Jersey. They all have the same decision, right? Yeah, they all have the same decision. Zero says, so their options are remove the questionable material or allow class disruption by opt-out policy. Exactly, yeah. So they are claiming, and I'll tell you what's surprising. And I'm going to go back through that decision and really look at it. But there's a Supreme Court case, and it's one of my favorite cases of all time. It's called Tinker v. Des Moines? Hang on. I can't believe I forgot. I'm sure Mark will get it before I do. Yeah, Tinker v. Des Moines. So a bunch of students were protesting. Their parents were protesting the Vietnam War, and they wanted to side with their parents. So they wore black armbands to, like mourning bands, to protest the Vietnam War. And they were kicked out of school for refusing to take them off. And the Supreme Court ruled that the school board had erred in their policies. They said that as long as the clothing that students wear does not actively disrupt the classroom, that they have the right to freedom of expression in what they wear. And I am kind of surprised that we don't see or at least from what I read so far, that we don't see in either side bringing in Tinker v. Des Moines. But I'm going to look through it again and see if I see anything in there. In fact, let's Control F this bitch. Tinker. It is in there. Okay. It's in the opinion of the court. And yeah, so the court cited it twice. Hey, smart people. Margaret says parents' rights to what they want their children to read supersede all arguments. I agree. What's up, shit? How you doing, man? I still love that PFP. Probably one of the best on YouTube. KC Cheetah with the very, very nice and very cool PFP says these streams are so informative. Plus, it's nice to get legal info from a lawyer. Thanks, Kings. You are very welcome. Do not forget, this is not legal advice. You have to pay for that. what actual harm does the school claim by opt-out? So they're claiming that the disruption of the classes by opting out. So I imagine what the classroom is looking like is, it's 9 a.m. or, everyone shows up 8 a.m. 9 p.m. No, 9 a.m. is book time or something, science class, whatever. And they pull out the gay book and they say, okay, we're going to the book now. John Boy, Danny, Sarah, Lisa, Mary, your parents don't want you in here, so y'all go out and sit in the hall. Okay. And then they read the book and then they go back in and say, okay, y'all come back in. Something along those lines they are claiming are disrupting the classroom too much. That kid lost court case in Massachusetts, only 2 genders t-shirt. Oh. 2 genders t-shirt court case. So the Supreme Court declined to hear the case of a student who was prohibited from wearing a "there's only 2 genders" t-shirt to school. The court's decision leaves in place a lower court's ruling that upheld the school's ban on the shirt, finding it would negatively impact transgender and gender nonconforming students. So here's the thing. I don't disagree with them. I don't disagree with the lower court in that. While I completely agree with the t-shirt, a t-shirt like that definitely is going to affect the classroom. Whether you have now, if you could walk in and claim, there are no transgender or gay students in my classroom, so it doesn't affect them, maybe. But when you walk down the hallways, there's going to be any number of kids in the hallways, and that is going to affect the classroom then. So Tinker does work with that, saying that it does still affect the classroom eventually. It still gets to the classroom. So while I agree with the t-shirt, I do also have to agree with the court in that. Intent to provoke. So, I mean, that's the thing. Like, there was the thing a while back, probably about 15 years down here in South Carolina, where I forget the exact stuff in it, but it basically involved a kid wearing a Confederate flag, well, a Stars and Bars flag, and because don't forget there were about 9 different Confederate flags. So he's wearing a Stars and Bars. It was either on like a T-shirt, might have been on his hat or something, and he was told to remove it. So I think it was on a hat. He was told to remove it, and he gets up and starts saying, "Oh, freedom of speech, freedom of speech," and he was asked to leave. I think he made it to the principal's office and eventually was convinced to take it off or something. I really don't remember a lot of it. But they argued that he had a history of like trying to get people angry, and that the intent of wearing the hat was to get people angry. Again, I'll spend some time trying to find it. Let me write this down. You would think I would actually have a fucking pen near me. Oh. Woo! Let's see. Fan flag in school kid. Okay, I'm gonna look that up. I'm gonna see if I can find it. He's now wearing no women in girls' sports. Love this kid. Careful, he's under 18, buddy. Casey says freedom of speech only goes so far, like yelling fire in a crowd theater. Don't forget, Casey, that's not the full quote. Yelling fire in a crowd theater where there is no fire. And White Pine, how you doing, man? Dude, real quick, I was playing a little bit of Elden Ring earlier today, and I started a new playthrough. I did a new game plus. So might might be doing some new Elden Ring streams over on King's Advisors. So that's the thing. Like, even if it is a simple statement of fact, which I mean it is, it's still provocative. In Tinker, it was just a black thing around the arm that you can't really argue that's provocative. You can very well argue that a shirt like that is definitely provocative. Okay, what's happening on the scene? Oh, that dumb lady with the white hair is speaking now. Okay. Okay, so here's the big one, guys. Here's the big one. Percent. Yeah, let me make sure this is it. Yep. In the Supreme Court of the United States of America, Trump, President of the United States et al. Versus Casa Incorporated. This is grouped along with Trump v. Washington and Trump v. New Jersey, where I believe the attorney generals of both New Jersey and Washington State sued the Trump administration over his executive order number 14160. As the order sought to redefine the interpretation of the citizenship clause, asserting that children born to non-citizen parents were not subject to the jurisdiction of the U.S. and thus not citizens. So, lot to look through on this one. We're going to start with the 14th Amendment. Okay, so let me pull it up. Text. So here's the really annoying. Random. I did see your message. Let's see. How biased is this channel? Faux news level biased or just clickbait titles but credible legal opinions discussed? Ask for a friend. I mean, it's you figure it out, man. Just about everything I say is my opinion on how the courts have ruled, what the administration's doing, shit like that. I mean, I'm not going to sit there and say that I'm not biased. I'm 100% biased. I'm definitely biased. I think the court should rule certain ways. I think Trump is doing a pretty dang good job. There's stuff that I wish he wasn't doing. There's stuff that I wish he was doing better at. And I've called, mostly on live streams, I've called him out. I've said, there's certain stuff, but I'm not going to sit here and act like I'm legal or some bullshit like that. Let's look at the 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof. Zero, exactly. I'm biased to common sense. So, I would tell you to watch and make your decision based off of that. Don't listen to what other people say. If you think I'm wrong about something, tell me, but I'll go ahead and tell you that I think you're probably wrong. So let's go. All persons born or naturalized, no state shall make or enforce any law this case, yeah, okay. I mean, yeah, well, random. We'll get there. Like, there's a way you do these things. You explain the background. You explain what the executive order does, and then you explain what the case decided. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person or life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protections of law. And don't forget, the reason the 14th Amendment was passed was because many states had created what was basically called the grandfather rule, which was that after the Civil War, after the what was the Juneteenth thing? The Emancipation Proclamation. There were a bunch of states that basically had, and if it wasn't a law, it was a rule, that in order to be a citizen, in order to have constitutional rights, your grandfather had to have been a citizen. And so there were all these ways to basically try to prevent people, whether they were Chinese immigrants or blacks or Irish or Europeans they didn't like, or Protestants, depending on what state you were in, or Catholics. It was a way to try to prevent people from maintaining rights they had under the Constitution. So this amendment gets passed, and it was basically to say everyone, basically at this point, everyone in the country is a citizen. If you were born here, you're a citizen. The problem is that birthright citizenship has exploded into a tourist industry where you get people from all over the world that come here, whether legally or illegally. They have a kid, and then they decide that keeps them in the country. And the question is, does it? So we really only have one case that actually answers this decision, and it's the U.S. versus Wong Kim Ark. U.S. v. Wong Kim Ark. I'm sure I'm saying that wrong. And if you're ever curious about what a Supreme Court case does, Oyez is a very good reference. I used it all throughout college, all throughout law school. It's very good. And it's, for the most part, it's pretty matter of fact. It doesn't do a lot of, well, we think. It's very matter of fact. So the facts of the case were the Chinese Exclusion Act denied citizenship to Chinese immigrants. Moreover, by treaty, no Chinese subject in the United States could become a naturalized citizen. Wong Kim Ark was born in San Francisco to parents who were both Chinese citizens who resided in the United States at the time. At age 21, he returned to China to visit his parents who had previously resided in the United States for 20 years. When he returned to the United States, Wong was denied entry on the grounds that he was not a citizen. So the question was, is a child who was born in the United States to Chinese citizen parents who are lawfully permanent residents of the United States a U.S. citizen under the Citizenship Clause of the 14th Amendment? And the conclusion was, because Wong was born in the United States and his parents were not, quote, employed by any diplomatic or official capacity under the Emperor of China, the Citizenship Clause of the 14th Amendment automatically makes him a U.S. citizen. Justice Horace Gray authored the opinion on behalf of a 6-2 majority, in which the court established the parameters of the concept known as just solely. Yes, 0. 100%, man. In which the citizenship of children born in the United States, non-citizens, Justice Joseph McKenna took no part in the consideration or decision of the case. I wonder why. So Oyez is good. So is... I don't see it on here. The other one I used to use all the time. Give me a case. Tinker v. Des Moines. Oyez, and then maybe Oyez is the one I'm thinking of. Yes. Okay. So the other thing that's kind of cool about Oyez is they might not do it on really old cases because the photos don't exist. But on here's Tinker, they actually have the pictures of the justices, and it shows you which ones dissented or did not participate. I always thought that was pretty cool. Okay, so I want to view the case. Let's see, because I want to see this test. And what I don't want to do is I don't want to go and Google what the test is, because what you're going to get are non-legal examples. So you'll end up with a blog or a YouTube channel that says this is what the test says, and they might be pretty close. But the problem is if it's not the exact language, or they try to break it down in a different direction, then you end up with the same kind of issue that we have with the Bible and other religious texts that have been translated 40 different times. Is you end up with something that doesn't quite mean what it originally said. And am I an originalist? I think I'm a moderate originalist. So, if for those of you that don't know, an originalist, random, correct me if you view it in a different way, but an originalist basically believes that the Constitution is the Constitution and means what was written in 1789, and it does not change. Anton Scalia was a originalist. There are other people that believe that the Constitution is a living, breathing document and that it changes as the times change. And yeah, so that's the thing, Independent. I'm so glad you brought that up. Okay, you know what? We're going to kind of go off on a tangent here. I'm going to see what AI, with ChatGPT, that kind of shit gives me for this. Difference between No. I love tangents. Difference between a textualist and an originalist for the U.S. Constitution. Because there's a different, but it's very like, I hate to quote Doctor Who, timey-wimey bullshit. Okay, so Grok says, a textualist focuses on the plain, literal meaning of the Constitution's text as it was written, prioritizing the words themselves over external context. A textualist interprets the text based on its ordinary meaning at the time it was adopted, without necessarily delving into the framer's specific intentions. For example, a textualist might focus on what equal protection means in the 14th Amendment, based solely on the text and its common usage in 1868. Originalist emphasizes the original intent or meaning of the Constitution as understood by its framers or the public at the time of its adoption. Originalist aims to interpret the Constitution based on the historical context, intentions, or public understanding of the document when it was written. This may include examining historical records, debates, or writings from the period. So, let's see, just so I don't forget, I was asking mainly to bring up the House Joint Resolution 127, but going back to it, what you said, strict religion or constitution, I think, but Scalia, Thompson, don't follow that as rules. So, textualists, if I was going to put this in contract terms, textualists look at the four corners. And what that means is a textualist only looks at the document. They do not look at outside stuff. They don't look at what was in Thomas Jefferson's journal. They don't look at what was in James Madison's notes on what was going on. They don't look at the Federalist Papers, anything like that. An originalist looks at the document and then goes, okay, we don't really know what this means. So let's see if James Madison said anything about this. Or let's see if when the Federalists were writing their papers, let's see if they said anything about this so that we can understand what their meaning was. In that case, I think I'm more of an originalist. I think it's important to understand the context. I mean, especially being an attorney, think about this. So when we're writing, and I mean, I don't do a lot of authoring shit anymore because I do real estate now. But if I'm going to sit there and I'm going to write a argument, then I'm going to pull from every single source I can to prove my point. And a paper authored by James Madison in 1790, a year after the Constitution takes effect, about what the Second Amendment says, would be a good source for my argument. So I think it's an important thing to look at. But I do not think that a book about the Founding Fathers written today based on third and fourth and fifth sources is a good thing to look at. I give you an example. Harvard, I don't know if they still use the book, but Harvard had a book in there. I think it was like basically their Poli-Science 101 class that I don't remember what the book is, and I'll see if I can find it later. But when you go to the end of the book, where you would normally find the works cited, there was a paragraph that said, we have decided to do away with the normal works cited page and are basically saying that since we're Harvard educated people, you should trust us. That's what their works cited page said. The problem is the book argued that about 97% of the founding fathers were atheists, which all other scholarship disproves. Bruce Wayne says, I'm sick of the debate. The original document and 0 changes. I still think that you should have to own property to vote. I think it's ridiculous that the homeless guy's vote means the same as my vote. The decision doesn't affect the homeless guy nearly as much as it affects me. White pine, that's a whole different thing here. Okay, so Wong is United States v. Wong arc. I'm sitting here trying to find the test that they created in this case. So let's control F. I don't know, 2. This might be the test. No, that's from Blackstone. Smart dude, Blackstone. Let's see. Nope. I can't find it. Let's see. What is the test? Hang on a second. No. White Pine. I didn't say they were atheists. They weren't atheists. In fact, there's only one of them that was a agnostic. The rest of them were at the very least theists, while about of the 55 that signed the Declaration of Independence, 54 of them were Bible-believing Christians that attended church on the regular. I was saying that there was a book that said they were atheists. Yeah, random. So that's the thing. I mean, and you'll see when I pull up the next opinion, is that opinions can be very annoying to get through. So this is the issue here, I think. The question that the Supreme Court had to answer, and we can look it up on the Wong case itself. Let me get the citation for Wong. 16 U.S. They should have the question in here. Okay, I don't care. Let me share this tab instead. We should get to the question here in a second. These are the facts of the case. Here we go. The question presented by the record is whether a child born in the United States of parents of Chinese descent who, at the time of his birth, are subjects of the Emperor of China, but have a permanent domicile and residence in the United States and are there carrying on business and are not employed in any diplomatic or official capacity under the Emperor of China, become at the time of his birth a citizen of the United States by virtue of the first clause of the 14th Amendment of the Constitution. So here's the issue. The question before the court should be, what does the status of the parents have to be? Oyez refers to the status of the parents basically needing to be lawful permanent residents. Okay, well, you could be a lawful permanent resident of the United States in several ways. I read it as you need to be in this country lawfully. The problem is most of the people claiming birthright citizenship do not have parents that that are in this country illegally. So let's look at the case. Again, like I think Random is the one that mentioned it up at the beginning. Yes, so this case itself is about universal injunctions. So the court has ruled that judges cannot give, well, I don't know if cannot, let's look. Universal injunctions likely exceed the equitable authority that Congress has given the federal courts. The court grants to the government's application for a partial stay of the injunctions entered below, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff withstanding to sue. So again, these injunctions that these federal judges keep issuing, they're national injunctions, and the injunctions are stopping the federal government from doing so many things. You can't really even make a list of them. And so what this court is saying here is that basically federal judges cannot make injunctions covering people that are not plaintiffs in their cases. Random, what are we talking about here? Which HR 127? Every time there's a new Congress, there's a new HR 127. Give me a year. Current Congress, 2 Congresses ago, 3 Congresses ago. 39th Congress. HR 127. Oh, okay. So what became well, see, again, so this is going to be an interesting debate is just because it's around the argument of HR 127 doesn't mean it's actually in the body of the amendment. So if we go back and look at the amendment, this is what it says. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Let's see. Representative portion of the several states. Yeah. Oh, public debt. That's a fun one. We don't see, but this is the thing. You don't have to go by the plain text. Depends on how you read the Constitution. Again, it's depending on how, even then, it would depend on how you read the amendments. I would argue that you should be a textualist for the Constitution, but you should view amendments differently, because amendments are not were not debated like they were, like the Constitution was. Let's see. Oh, that's an interesting way. And again, if you're a textualist, okay, well, what's the definition of a citizen in, what was it, 1860, right? 1868? 66, 68. So if you're a textualist, then what's the definition of citizen or born or naturalized in at that time period? It's sort of like when people argue the Civil Rights Act, or they argue what is that one? The Equal Protection Clause. They argue it based off of shit they think of today, when it doesn't. There are people that argue that, or say that the Equal Protection Clause extends to gender, and it doesn't. They say that you can't discriminate based on your gender identity. And it's like, you absolutely can, because it's not, that wasn't the definition used in 1964 when it was passed. 64, I think. No, it's definitely not. It's not irrelevant. It's absolutely relevant. Every single word used in this is relevant. What is the definition of a citizen? At that, I would argue you need to go see what we were arguing and what we were debating in 1868 when this passed. I would say you also need to look at what was going on. Okay, well, why was this amendment added? It was added to prevent the shit that was going, that I talked about earlier. So using this amendment that was used to try to fix the shame of slavery to argue that anyone that walks into this country and gives birth automatically has a United States citizen in their hands is bullshit. Okay, let's look at this case. I'm getting off on a tangent. I don't need to do that. I want to go to, and this is the one that Barrett wrote, right? Yeah. Justice Barrett delivered the opinion of the court in which Roberts, Thomas, Alito, Gorsuch, and Kavanaugh joined. Thomas filed a concurring opinion that Gorsuch joined. Alito filed one that Thomas joined, and Kavanaugh filed one as well. Sotomayor, Kagan, and Jackson dissented, and Jackson filed the dissenting opinion. Who's y'all, random? There's no one else here with me. This is just me. Let's see. 3 emergency applications. Like I said, this is 3 cases. It's v. Casa, v. Washington, and v. New Jersey. The United States filed 3 emergency applications challenging the scope of the federal court's authority to enjoin government officials from enforcing an executive order. Traditionally, courts issued issued injunctions prohibiting executive officials from enforcing a challenged law or policy only against the plaintiffs of the lawsuit. The injunctions before us today reflect a more relevant development. District courts asserting the power to prohibit enforcement of a law or policy against anyone. These injunctions, known as universal injunctions, likely exceed the equitable authority that Congress has granted to federal courts. We therefore grant the government's application to partially stay the injunctions entered below. Don't forget that the Article 3 of the U.S. Constitution, which creates the judicial branch, created only one court, the Supreme Court, and it then delegates to Congress the ability to create different courts. The obligation before us concerned 3 overlapping university preliminary injunctions, yada, 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 yada. Doesn't really matter what's 3. I believe all 3 were related to lawsuits involving Executive Order 14160, which is the one that sought to redefine the interpretation of the citizenship clause. I need some water. Guys, I will be right back. I'm going to go get some water. So give me 1 second. All right, I'm back. Let's try that now. Let's see what the chat's saying. Anarchy. You're all wrong. The King of England is going to march on in here and kick some chairs or something. Well, I don't think the King of England can get off his chair. Well, Clyde, so that's the thing. I'm glad someone mentioned that. I'm still waiting on him to do literally the funniest thing he could do and tell Congress or tell Parliament to fuck off. That would be hilarious. Let's see. The application before us concerned 3 overlapping universities. Yeah, like I said, they're all for Executive Order 14160, which sought to redefine the interpretation of the citizenship clause. So I still don't think it really contradicts what was it called? Wong Kim. Because again, if the question is a child who is born in the United States to parents who are lawful permanent residents of the United States, a U.S. citizen, then that's fine. If we're going to look at the definition of the parents, it looks like I'll go back and I'll read Kim later, but it looks like that's one of the things the court wanted to do in Kim. They wanted to see what the parents were. Once you cross the border illegally, you're no longer a lawful resident of this country. And so your kids shouldn't have protections that aren't warranted. Let's see. So the lower court ruled that federal district courts in Maryland, Massachusetts, and Washington issued universal injunctions blocking the order's enforcement nationwide. Let's see this. Let me open this back up. Let's see. If the birthing tourists were not treated as hostile under duress by their mother country, with following chain migration, would we view it as strictly currency street? Bruh, White Pine, will you rewrite that for me? Because I don't understand what you're saying there. Let's see. The government does not dispute, nor could it, that the individual plaintiffs have standing to sue, but it argues that the state lacks third party standing because their claims rest exclusively on the rights of individuals. Application for partial stay of injunction in number 24A884, blah, 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 sums the district court's authority to grant relief to the organization's members who are not identified with complaints. So they are not addressing these arguments. Let's see. It says for, so it should be let me pull up the executive order. Let's get 14106, 14160. By the authority vested in me, President of the United States, the privilege of United States citizenship is a priceless and profound gift. The 14th Amendment states all persons born or naturalized in the United States and subject to the jurisdiction thereof. Yeah, we've read all this several times. That provision rightly repudiated the Supreme Court of the United States' shameful decision in Dred Scott v. Stanford, which misrepresented the Constitution as permanently excluding people of African descent from eligibility for the United States citizenship solely based on their race. But the 14th Amendment has never been interpreted to extend citizenship universally to everyone born within the United States. The 14th Amendment has always excluded from birthright citizenship persons who were born in the United States but not subject to the jurisdiction thereof. Consistent with this understanding, the Congress has further specified through legislation that a person born in the United States and subject to the jurisdiction thereof is a national and citizen of the United States at birth. Generally mirroring the 14th Amendment's text. Among the categories of individuals born in the United States are not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend to the persons born in the U.S. When that person's mother was unlawfully present in the United States and the father was not a United States citizen or lawful permanent resident at the time of said person's birth, or two, when that person's mother's presence in the U.S. at the time of said person's birth was lawful but temporary, such as but not limited to visiting the United States under the auspices of the visa waiver program or visiting on a student, work, or tourist visa, and the father was not a United States citizen or lawful permanent resident at the time of said person's birth. It is the policy of the United States that no department or agency of the United States. Hang on, I want to read that again. Among the categories of individuals born in the United States and not subject to the jurisdiction thereof, the privilege of the United States citizenship does not automatically extend. Okay, so using that argument, it is the policy of the United States that no department or agency of the United States government shall issue documents recognizing United States citizenship or accept documents issued by state, local. So, persons one, when that person's mother was unlawfully present in the United States and the person's father is not a United States citizen or lawfully present. When that person's mother's presence in the United States. So, this is just a repeat of what we read up here. Subsection A of this section shall apply only to persons who are born within the United States after 30 days from the date of this order. Nothing in this order shall be construed to affect the entitlement of other individuals, including children of lawful permanent residents, to obtain documentation of their United States citizenship. The Secretary of State, the Attorney General, and the Secretary of Homeland Security, and the Commissioner of Social Security shall take all appropriate measures. Okay, so this is just how they're going to do it. Okay, so this is the. I think this is the one of the ones he signed on the stage. The plaintiff files suit alleging I don't really care about the histories of these cases. I want to see what I guess their opinion on the injunctions are. A universal injunction can be justified only as an exercise of equitable authority. Yet, Congress has granted federal courts no such power. The Judiciary Act of 1789 endowed federal courts with jurisdiction over, quote, all suits in equity. And still today, this statute is what authorizes the federal courts to issue equitable remedies. Though flexible, this equitable authority is not freewheeling. We have held that the statutory grant encompasses only those sorts of equitable remedies traditionally accorded to courts of equity. Buddy, I'm on page 11. I'm already there. Most of the beginning of this opinion is talking about the history of the case. That's how these things work. This is not the first time I've read one of these. We must therefore ask whether universal injunctions are sufficiently analogous to the relief issued, quote, by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactments of the original Judiciary Act. Because again, what they have to do when they decide these things is they have to say, okay, this is what Congress said. This is the law they made. So in order to figure out what they mean by this sentence, we have to see what they were basing it off of. And they have to base it off the High Court of Chancery in England at that time. The answer is no. Neither the universal injunction, nor any analogous form of relief was available in the High Court of Chancery in England at the time of the founding. Equity offered a mechanism for the Crown to secure justice where it would not be secured by the ordinary and existing process of law. The origin of English equity, this judicial prerogative of the king, thus extended to those causes which the ordinary judges were incapable of determining. Eventually, the Crown, I'll tell you what, this must have been a really difficult decision to write because they spend so many of their decisions are based on cases that have 30, 40, 120, 200 years of precedent. And so they don't have to go back to the founding. They don't have to go back to English common law or Blackstone. They go back to Blackstone a lot because it's such a secure place to start your decision. But having to go back to the English common law and really not really be able to cite anything that's younger than 200 years is wild. Where was I? Of importance here, suits in equity were brought by and against individual parties. Indeed, the general rule in equity was that all persons materially interested in the suit were to be made parties to it. Injunctions were no. That's why. What are they called? That's why class actions can have open classes and closed classes. An open class, as if the class action or if the case goes with the plaintiffs on that, then anyone that could have been in the class can still register and receive their portion of the payout. If it's a closed class, then only named members of the class are able to receive their payout. Let's see. Nor did founding era courts of equity in the United States chart a different course, C1 Pomeroy. Remember, this is the case where I think it might have been Justin Barrett. But I think it was one of the female justices kept peppering the Department of Justice on whether or not judges prior to basically 1970 used nationwide injunctions. Let's see. Let's get to the bottom line. The universal injunction was conspicuously non-existent for most of our nation's history. Its absence from 18th and 19th century equity practice settles the question of judicial authority. The principal dissent faults us for failing to identify a single founding era case in which the court held that universal injunctions exceed a federal court's equitable authority. But this absence only bolsters our case, that the court has no occasion to reject the universal injunction as inconsistent with traditional equity practice, merely demonstrates that no party even bothered to ask for such a sweeping remedy, because no court would have entertained the request. White Pine, I would argue any any court decision that changes what Congress or the executive does is legislating from the bench. Precedent in general is a court's ability to legislate from the bench, but then also I would argue that legislation is technically permanent, and a injunction is not. So I would argue if I was on the no or on the pro injunction side, I would say it's not legislating because they're not permanent. So, and because of the nature of legislation, in its permanence, you can't. They are not equal. So you can't say that's legislating because the equitableness of them doesn't exist. I don't know if that made any sense. But being on the con side, I would argue that the court's ability to throw out Congress's or the executive's decision is for the country worldwide is definitely legislating from the bench. Yeah, legislation really should be unambiguous. So this is the problem with legislation. Okay, I do want to pull up. Let's see, SC code, no, SC laws. So we're going to pull up the South Carolina Code of Laws. We're going to go to, let's say, title. What's something we're all interested in? Let's go to Title 7, elections. Okay, let's look at this real quick. So it absolutely should be plain English, as most as you can, as close to plain English as you can get. So we look at polling precincts and voting places. For the purpose of holding any general, primary, or special election in this state, the voting precincts and voting places in the several counties of the state shall be designated, fixed, and established by the General Assembly. Nothing in this chapter prohibits a county board of voter registration and elections from establishing multiple polling places within a precinct, provided that voters are assigned to these polling places alphabetically or geographically, as determined by the county board of voter registration and election and approved by a majority of that county's legislative delegation. A voter must be notified in writing of his transfer to a new polling place and the location of his new polling place. Now, the issue is that is pretty plain English there. There's not really any legalese. The legalese in that is just their choice of using words like the state, designated, established, the General Assembly, things like that. The problem is that you end up in something deeper in here, where you see Are these all the districts? Oh, these are all the precincts in Aiken County. That's cool. I did not know all this stuff was in here. That is actually pretty neat. The issue is that you get into codes and areas of law, especially in the federal government, where they can't put it in plain English because there are what we call phrases of art that mean specific things. And if you don't use that phrase of art, then it doesn't mean what you want it to mean. And that's the problem. Okay, we're going to be done with that. We're going back to this. Casey says, I'm not a lawyer, but if this is how all interpretation of constitutional laws are formed, this is so far over my head. So, Zero is completely right that this is a rabbit hole of rabbit holes. I think the problem becomes when you're unable to kind of take the time. Like, a lot of people don't have the time to sit down and read this decision, and then from this decision go read the other cases. Now, that is one of the reasons why they cite them. That's one of the reasons why they use the phrases that or the sentences that they're using in the cases in the opinion. But we all know that taking a sentence from this thing over here doesn't necessarily mean what we want it to mean. So you really should look at the context. So then you take time to go read that case, and then, well, where did they get that context from? It's a fucking annoying rabbit hole. So White Pine, I'm gonna answer this, and then we're gonna get back to the decision. If we institute term limits and booted the lobbyists, how much worse off would we be? So I think that's interesting. I've always maintained that we shouldn't need term limits. I think that's the reason why they weren't put in the Constitution, because our founding fathers believed that the people that were going to be in charge would be too busy in their normal lives to actually be full-time legislators. It's one of the reasons why the legislative session was put where it was at the beginning, was because it was after the not the legislative session. The reason voting was put in November was because it was after the harvest, and the farmers and everyone had time to go vote because of that. So I think the opinion was that, and especially because this is what, 90 years after the death of King Charles I and what's his face's glorious revolution, when Cromwell kicked Parliament out because they were basically only doing the job so they could make money, and that's why he removed them. So he used the army to do it. They believed that Congress shouldn't make that much money, and they didn't at the beginning. Like Zero says, they made it per diem. And so I think the problem becomes the fact that it's an actual job now. Now, why is it an actual job? Well, we are a much bigger country now. The laws are a little more complicated. There's more debate. There's more issues today than there were in 1780, 1790, 1880. So what I think would change this is a campaign to make us smarter voters. At the end of the day, if the voting population was smarter, and I don't even mean if they went to college or if they did this, I just mean if they were actually intelligent voters. then we wouldn't have this problem. South Carolina would continue to elect Lindsey Graham. Because the overall voter in South Carolina is clearly an idiot, we keep electing him. I haven't voted for Lindsey Graham his last 2 times being up because I don't think he's a good senator. I think more informed is exactly it, Zero. They don't need to be more intelligent. They need to be more informed. South Carolinians need to be aware of the fact that Lindsey Graham wanted to go to war. We don't want more war. We've seen it. We don't want more of it. So let's get rid of Lindsey Graham. The problem is once Lindsey Graham puts that R next to his name, South Carolinians become blind. And all they see is an R. And so 55% of them vote for it because they see R. 45% vote for the D because they see a D. That's the problem. And what's going to suck is a third or fourth or fifth party doesn't even fix that problem, because we've had different parties in this country. We had the Green Party. They didn't do any shit. They ended up being absorbed by the Democratic Party, which is why you have people like AOC and the Squad. What does Trump say? AOC plus 3, which is beautiful marketing. That's why you have the Tea Party ends up getting absorbed by the Republican Party, and you have a sect of the Republican Party that's a lot more conservative than the general Republican. So that's what ends up happening here. And the problem is, the reason is because any group of people that decide to form these third, fourth, and fifth parties, it's going to happen to Elon Musk if he tries to do this American party, is they go after the president. They say, oh, we're going to spend $90 million running for Congress and the presidency every 4 years. And it's like, hey, dumbasses, why don't you spend $1 million throughout the 50 states running for school board and city council and the House of Legislature and all that shit? Run for fucking coroner. But you're not going to get third, fourth, and fifth parties enshrined in the democratic process until you get fucking members of that party actually in Congress, whether it's state Congress, whether it's federal Congress, whether it's the school board. It's not going to happen. But they won't put in the time or effort or the money to do it. That's the problem. Welcome to my rant. Let's see. Where were we? So this is what she was talking about. So what exactly, Hokies? Local elections matter. What Barrett is saying here, and this is one of my favorite things Barrett says. Faced with this timeline, the principal dissent, Justice Jackson's dissent, accuses us of misunderstanding the nature of equity as being frozen in amber at the time of the Judiciary Act. Wait, hang on. Here we go. No, this is the one I like. Here we go. Its absence from the 18th and 19th century equity practice settles the question of judicial authority. And then it's a footnote. You come down here and read the footnote. The principal dissent, Justice Jackson's dissent, faults us for failing to identify a single founding era case in which this court held that universal injunctions exceed a federal court's equitable authority. So what Justice Jackson is saying is that the majority was unable to find an actual case where we, the Supreme Court, said judges can't issue federal injunctions or nationwide injunctions. And there, Justice Jackson acts like this is a win, that she's proven that these 6 justices are using their ties to Trump or the Republicans or the right or whatever to legislate from the bench. And what Barrett is saying is that the complete fact that they don't exist at all, that the judges in the 18th and 19th century never did one, and that the practice to not do it extended into late into the 20th century proves that that power did exist. That this court had no occasion to reject the universal injunction as inconsistent proves that no one ever did it. Margaret, you have fun, be safe, and have a great night. Oh, it's 6 o'clock. Wow, I've been around this almost for 2 hours. Okay, I want to get through this one quickly because I do want to hit. Which one was it? I think it was Free Speech v. Paxton. Yes. And that's the one that's probably going to get the channel taken down. Still the opinion of the court. Oh, hang on. This is why I do really like this one. We will not dwell on Justice Jackson's argument, which is at odds with more than 2 centuries of precedent. Okay, so Justice Jackson's argument, do I have a citation here? Hang on. Rhetoric aside, Justice Jackson's position is difficult to pin down. She might be arguing that that universal injunctions are appropriate, even required, whenever the defendant is part of the executive branch. If so, her position goes far beyond the mainstream defense of universal injunctions. Nationwide injunctions come with significant costs and should never be the default remedy in cases challenging federal executive action. That's a New York University Law Review. As best we can tell, though, her argument is more extreme still, because its logic does not depend on the entry of a universal injunction. Justice Jackson appears to believe that the reasoning behind any court order demands universal adherence, at least where the executive is concerned. So they're citing her dissent, page 2. In her law-declaring vision of the judicial function, a district judge's opinion is not just persuasive, but has the legal force of a judgment. But see Hallen v. Bracken, is federal court's judgment, not its opinion, that remedies an injury. Once a single district court deems executive conduct unlawful, it has stated what the law requires, and the executive must conform to that view, ceasing its enforcement of the law against whom anyone anywhere. 17. Think about what this position means. If a judge in the District of Alaska holds that a criminal statute is unconstitutional, can the United States prosecute a defendant under that statute in the District of Maryland? Perhaps Justice Jackson would instinctively say yes. It is hard to imagine anyone saying no. But why, on Justice Jackson's logic, does it not violate the rule of law for the executive to initiate a prosecution elsewhere? Among its many problems, Justice Jackson's view is at odds with our system of divided judicial authority. See this court's Rule 10A. It is also in considerable tension with the reality. Wow, I can't read tonight. With the reality that district court opinions lack precedential force, even vis-a-vis other judges in the same judicial district. And that's another thing. So when district judges, basically trial court judges, when they make a ruling, it's not precedent. It doesn't hold anyone else to that ruling. Only when the Court of Appeals and above makes a ruling is it precedent. And when the Court of Appeals makes a ruling, it's only precedent in that district. It's persuasive in other districts. So, like, if the Fourth Circuit makes a ruling saying murder is A, B, and C, then someone in the Second Circuit could cite that ruling and say, John didn't commit murder because of this, and we think that this opinion from the Fourth Circuit should be persuasive upon you, a judge in the Second Circuit, to follow what the Fourth Circuit said. But that judge in the Second Circuit could say, hey, go eat rocks. Fuck no, I don't have to listen to that bitch. I don't have to listen to anyone but me, God, and the fucking Supreme Court. That's it. And that's one of the reasons why the Supreme Court got real pissed off on Tuesday, I think it was. So they issued that order on Monday. What was it about? I made a video about it, but I've made so many, I kind of forget what all of them are about. Oh, I lost a sub during this live stream. Huh. Somebody didn't like my live stream. I wonder who it was. Let's see, what was it? Oh, it was one of these ones. So, it was the deportation delays. So there was a order out of, I think, Maryland. There's district court in Maryland that said you cannot deport to third party countries, basically a country that isn't the U.S., which we don't deport to the U.S., or that person's country of origin. You can't deport to anywhere else. You can only deport to their country of origin. And Trump was deporting to third party countries who would accept people, kind of like El Salvador. And so this put a hold on that. And then please don't, Clay. And then a district judge told the government, this ruling does not apply to my order. And so the Department of Justice went back to the Supreme Court asking them to tell the judge that it does apply to their order. I'm not sure what the Supreme Court ended up saying when it came to that, but that shit is going to get real. We're going to have a judicial issue coming up soon if these judges don't start listening to the Supreme Court. Let's see. No one disputes the fact, and again, no one disputes that the executive has a duty to follow the law, but the judiciary does not have unbridled authority to enforce this obligation. See Marbury v. Madison, one of the landmark decisions of the United States Supreme Court. One of the decision that created the ability for the judiciary to not just review, but to overturn Congress. Now, again, Marbury v. Madison, and anyone that tells you that Marbury v. Madison created judicial review is a liar. It did not. I can't give you the case that did because I forgot what it's called, but there was a case about 4 years earlier. That is what created judicial review. It was the first time Congress reviewed, the first time the judiciary, the Supreme Court, reviewed Congress. Let me see if Groff can give it to me. First time the SCOTUS reviewed. I bet you it's going to give me Marbury v. Madison. Let's see. Nope. This is not true. Okay. This was not the first time. It was the first time the SCOTUS overturned Congress. I want the first time they reviewed Congress. Let's see if it gives it to me now. Hilton v. U.S. There we go. So that's what it was. Hilton v. U.S. Congress passed a federal tax law in 1794 imposing a tax on carriages used for personal or business purposes. Dale Hilton, a Virginia merchant, challenged the tax, arguing it was a direct tax that under Article 1, Section 9 of the Constitution must be apportioned among the states based on population. He claimed the carriage tax was unconstitutional because it was not apportioned. The issue was, did the carriage tax violate the Constitution's requirement that direct taxes be apportioned? The Supreme Court ruled that it was constitutional. So again, it was Hilton v. U.S. was the first time the Supreme Court reviewed Congress. Marbury v. Madison was the first time the Supreme Court overturned Congress. Let's see. may a federal court in the United States of America order the executive to follow the law. In other words, it is unnecessary to consider whether Congress has constrained the judiciary. What matters is how the judiciary may constrain the executive. Justice Jackson would do well to heed her own admonition. Everyone from the president on down is bound by the law. That goes for judges too. God, they just ruined this woman. So how long do you think her so this is Justice Thomas's concurrence, which was actually quite short, which is pretty standard for Justice Thomas. Like it must be super easy to be a clerk for Justice Thomas. Let's see. Kavanaugh concurring. Now, don't forget, concurring opinions, they're not, most of the time, a concurring opinion is a justice saying yes, but. So in some cases, a justice will write a concurring opinion if they agree with the end, but they don't really agree with how the court got there. So, let's, if in this case, if Barrett said, this is the opinion from here to here, and, Kavanaugh could say, yes, I agree, this is where we end up, or this is where we end up, but I think it's this way. Thomas might say, I agree, but I think it's this way. And so I want to see how long. So this is Sotomayor's dissent. I thought Jackson wrote the dissent. Did they all write a dissent? This is still Sotomayor dissenting. Holy shit, this is a long dissent. Okay, here's Jackson's dissent. Justice Jackson dissenting. I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. It is important to recognize that executive's bid to vanquish so-called universal injunctions is at bottom a request for this court's permission to engage in unlawful behavior. When the government says do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct, that is actually saying is that what it is actually saying is that the executive wants to continue doing something that courts determine violates the Constitution. Please allow this. So again, like this is what's so annoying is she's a United States Supreme Court justice, and she doesn't know the basics of the judicial system. A district court judge does not, by definition, know what violates the Constitution. Do you want to know how we know if something violates the Constitution? If the Supreme Court says it does. We can sit here and argue between ourselves, I think this violates the Constitution because, and I can sit here and say, I think it doesn't. You can sit here and say, this is why I think it does. Yeah. But at the end of the day, it doesn't really fucking matter what you and I say. The Supreme Court is the arbiter of what the Constitution says. It is not up to a district court judge to decide what violates the Constitution. They can say, I believe this executive order violates the United States Constitution. I have decided A. And then kick it upstairs. That's the system we have. Gosh, she's such, and y'all have seen that chart that shows how much she talks. I bet they hate going to listen to her now. I don't really want to see what she has to say. Who else? It's just her dissenting the rest of the way. So her dissent 119. I mean, that's a 21-page dissent. That's not too bad. Yeah, and zero. That's one of the reasons why Marbury. Well, not that's one of the reasons why John Marshall decided Marbury v. Madison the way he did, because the Jefferson was not going to appoint Marbury. And John Marshall knew there was no way they were going to be able to force Jefferson to do it. And so that he decided to say, we may agree with Marbury, but we have no right to enforce this because the law that Congress cited or that Congress made 5 years earlier is unconstitutional. Oh, I thought you were on vacation, Debbie. Aren't you on don't you have 2, or is that next week? Don't you have 2 weeks of vacation now? That's exactly it, 0. Again, what does Benjamin Martin say? An elected legislature can trample our rights just as easily as a king can. Well, a runaway judiciary can do the same thing. Okay. Free Speech Coalition v. Paxton. We are going to kind of fly through this one a bit. I am slightly concerned over what talking about this could do to the channel. We are 2 hours in. Usually, YouTube-wise, you can kind of do whatever the hell you want after an hour. But this one does, kind of scare me just because of what it's about. Okay. Whoops. Thank you, Jeremy. Okay, where are we? What are we doing? Opening this decision. So while I zoom in here, this is a lawsuit. This is a lawsuit between the Free Speech Coalition suing, I believe, the Attorney General of Texas. Yes, Paxton. Try to zoom in a little bit better here. It's still kind of hard to read, but real quick, I do want to see what's going on the Senate floor. So Blumenthal is talking now. I believe he's from Oregon. So they've just pulled out all the Democrats to get up there and speak. Okay. They should really just give up. The bill is passing. Get over it. Stop trying to launch campaigns from the Senate floor. Stop being retarded. VPN says hi. Let's see. The law, HB 1181, enacted in 2023, mandated that websites with more than 1/3 of their content classified as sexual material harmful to minors implement age verification systems to prevent minors under 18 from accessing such content. It also required health warnings about pornography's alleged risk. The law aimed to protect children, but raised concerns about adult access to protected speech and online privacy. This is the same sort of law that's passed in about 18 different states here in the United States. It's passed here in South Carolina. And basically what it required is adult websites have to create, I think adult websites based in the U.S. have to implement software that says, I guess when you open it, it wants you to certify who you are. So if you filed your taxes through the IRS, you know, they have the My ID thing. You have to send a picture of your ID. You have to prove who you are and that kind of stuff. My understanding is that these new websites require the same thing. And with the exception of, let's call it the hub, because every single time a state has passed this law, instead of requiring the software, the hub and all of its sister websites prevent you from accessing it in that state. So the Free Speech Coalition, a trade association for the adult entertainment industry, along with adult content producers and an anonymous creator, challenged the law, arguing it violated First Amendment rights by burdening adults' access to constitutionally protected speech and creating privacy risks through invasive age verification methods. So let's look at the procedural history. A federal district court in Texas granted a preliminary injunction in August of 23. The U.S. Court of Appeals for the Fifth Circuit reversed the injunction in 24, applying rational basis review, a lenient standard. Remember, I talked about this. I think I made a video about this. Did I? How is that video doing, by the way? Holy shit, is that what this one is? Hang on a second, guys. There's no. No, that's not it. What was the video where I did a video where I talked about rational basis review and all that stuff. Was it the TikTok one? No, because I just made fun of that guy. It wasn't that one. Maybe SCOTUS sites. Anyone know? It was the tranny video. SCOTUS sides with common sense against. It's not doing very well. Oh, well. So rational basis is the lowest form of review that the courts use. It basically boils down to, does the state have a rational reason for passing their law? As long as it doesn't affect a legal class like race, religion, or a quasi-legal class like gender, then they use rational basis. Let's see. Applying rational basis and upholding the provision as a legitimate means to protect minors, it maintained the injunction on health warnings as compelled speech. The Supreme Court agreed to hear the case on July 2nd of last year to address whether the Fifth Circuit erred in applying rational basis review instead of strict scrutiny. So again, strict scrutiny would appeal to cases dealing with oh, come on, Caleb. I'm going to look it up. I don't remember. Mark Reality would answer it real quick. Let's see. Strict scrutiny applies when a law infringes upon a fundamental right, like freedom of speech, or involves a suspect classification like race, national origin, or religion. So they argued, the Free Speech Coalition argued that the U.S. Court of Appeals erred in using rational basis because this is a violation of freedom of speech. And freedom of speech is a is a fundamental right. Flynn v. U.S. That's Hustler, isn't it? Hustler is involved in a lot of really fun First Amendment cases. HB 1181 triggers and survives review under intermediate scrutiny because it only incidentally burdens the protected speech of adults. Let's see. So the lower court, the Fifth Circuit, used rational basis. The Supreme Court is using intermediate scrutiny. Interesting. HB 1181 is subject to intermediate scrutiny. To determine whether a law that regulates speech violates the First Amendment, the court considers both the nature of the burden imposed by the law. I think it's Flynn. Imposed by the law and the nature of the speech at issue. Laws that target protected speech based on its communicative content are presumptively unconstitutional and may be justified only if they satisfy strict scrutiny. Basically saying a law that says you can't say this has to pass strict scrutiny. And laws that restrict only unprotected speech, such as obscenity, receive rational basis review. History, tradition, and precedent establish that sexual content that's obscene to minors but not to adults is protected in part and unprotected in part. So it receives intermediate scrutiny. Let's see. I'm more interested in the ending here. The opinion. Texas, like many states, prohibits the distribution of sexual explicit content to children. But although that prohibition may be effective against brick and mortar stores, it has proved challenging to enforce against online content. Absolutely. In an effort to address this problem, Texas passed a law which requires certain commercial websites that publish this material content to verify the ages of their visitors. This requirement furthers the lawful end of preventing children from accessing this content. I'm trying to censor what I'm saying a little bit. Let's see, but it also burns adult visitors of these websites who all agree have a First Amendment right to access at least some of the content that the website publishes. We granted a certiorari to decide whether these burdens likely render HB 1181 unconstitutional under the Freedom of Speech Clause of the First Amendment. We hold that they do not. The power to require age verification is within a state's authority to prevent children from accessing this material. And then this is just history of the case. I've already kind of explained it. If a commercial entity knowingly violates, let's see, it may also recover a civil penalty up to $10,000 per day that the website is non-compliant. When other states have imposed this sort of law. Let's see. To determine whether a law that regulates speech violates the First Amendment, we must consider both the nature of the burden imposed by the law and the nature of the speech at issue. Our precedents distinguish between two types of restrictions on protected speech: content-based laws and content-neutral laws. Okay, this could be technical, so bear with me. Content-based laws, those that target speech based on its communicative content, are presumptively unconstitutional. It may be justified only if they satisfy strict scrutiny. That standard requires that a law be the least restrictive means of achieving compelling state interest. Content-neutral law, on the other hand, are subject to an intermediate level of scrutiny because in most cases they pose a less substantial risk of excising certain ideas or viewpoints from the public dialogue. So content neutral, an example of that, I mean, this is an example of that, but if you were to pass a law that said you cannot promote communism. That would have to pass strict scrutiny. If you were to pass a law that says you cannot talk about politics, it's possible. Now, I think you'd probably have to pass strict scrutiny, but it's possible that because it's relatively content neutral, you'd have to pass intermediate scrutiny. That's sort of, it's not a great example because it's likely both would have to pass strict scrutiny. Yes, Hokie, sorry, I just saw your message. Do I know what Texas law required? Yeah, it basically just requires, I mean, I'm not telling you to do this, but if you were to go to the hub, if you're in one of these 22 states, you would get a notification. Well, actually, the hub has pulled out of every single one of these states, so you can't even access it. If you were to go to one of the other websites, it would basically ask you to certify who you are. Similar to how if you go to file your taxes on the IRS website, it asks you to do a certify ID type thing. Let's see. If we banned it all together, how much worse of a society would we become? One with more offenders or one with a moral strength increase? If we banned it all together, well, so here's the thing. That sort of thing, I don't think you can ban. I think it has to be a decision by everybody. Because once you ban something, you automatically have a group of people that no matter what are going to stand up for it. So I think if everyone decided we don't want this stuff in our schools, on our computers, in our movies, all that kind of stuff, I think we'd be better as a group of people. But the problem then becomes if Steven decides to make that movie and then we go after Steven, there's the problem. So the response to its reintroduction, I think, would determine what kind of society we had become. Content neutral laws, on the other hand, are subject to intermediate scrutiny. Turner Broadcasting v. FCC, that's a fun one. If it advances under this standard, a law survives if it advances important governmental interests unrelated to the suppression of free speech and does not burden substantially more speech than necessary to further those interests. I don't really want a definition of this stuff. Here we go. Casey, you have a good night. Thanks for being here. When regulating minors' access to this stuff, the state may broaden Miller's definition of obscenity to cover that which is obscene from a child's perspective. To be more precise, a state may prevent minors from accessing works that appeal to prurient interests of minors, depict or describe specifically defined stuff, taken as a whole, lacks serious literary, artistic, political, or scientific value for minors. Restrictions of this kind trigger no heightened First Amendment scrutiny and are subject only to rational basis review, even though they encompass speech that is not obscene for adults. In sum, two basic principles govern legislation aimed at shielding children from this stuff. A state may not prohibit adults from accessing content that is obscene only to minors, but it may enact laws to prevent minors from accessing such content. So, I mean, that's where we are. The state can say, we're going to pass a law that might force adults to take an extra step to access something. But as long as that extra step is done to protect the minor from seeing it, then it's legal. I'm curious what this is. Those are the 6-3 decision. So let's see. I wonder who the 3 dissenting justices are. I wonder. Here we go. Justin Kagan, Sotomayor, and Jackson dissent. No one doubts that the distribution of sexually explicit speech to children or the sort involved here can cause great harm. Or to say the same thing in legal terms, no one doubts that states have a compelling interest in shielding children from speech of that kind. What is more, children have no constitutional right to view it. The Texas statute before us addresses speech understood in First Amendment law as obscene for minors. That label means the First Amendment does not protect the speech for minors. The state can restrict their access without fear of colliding with the Constitution. The trouble comes in the last 2 sentences, italics. Is it these 2 sentences? That label means the First Amendment does not protect the speech for minors. The state can restrict their access without fear of colliding with the Constitution. The trouble comes in these. Can I highlight this? Yes. Okay. The trouble comes in the last 2 sentences, italics. Speech that's obscene for minors is often not so for adults. For them, the category of obscene and therefore unprotected speech is narrower. Sure. So adults have a constitutional right to view this very same speech that a state may prohibit for children. Agreed. And it is a fact of life and also of law that adults and children do not live in hermetically sealed boxes. In preventing children from gaining access to obscene for children speech, states sometimes take measures impeding adults from viewing it too, even though for adults it is constitutionally protected expression. What then to do? Cases raising, okay, I'm going to read a lot more of this than I would have read. I'm very interested in what they're going to say. Cases raising that question have reached this court on no fewer than 4 prior occasions, and we have given the same answer consistent with general free speech principles each and every time. Under those principles, we apply strict scrutiny, a highly rigorous but not fatal form of constitutional review, to laws regulating protected speech based on its content. And laws like HB 1181 fit that description. They impede adults from viewing a class of speech protected for them, even though not for children, and defined by its content. So when we have confronted those laws before, we have always asked the strict scrutiny question. Is the law the least restrictive means of achieving compelling state interest? There is no reason to change course. Okay, so does she argue okay, might argue that is no. Look, so far I'm agreeing with her, and Texas might be right in arguing that it has no least restrictive way to achieve that goal. It is difficult, as everyone also agrees, to limit a minor's access to things appearing on the internet. Agreed. If HB 1181 is the best Texas can do, meaning the means of achieving the state's objective while restricting adult speech's rights the least, then the statute would pass First Amendment review. But what if Texas could do better? What if Texas could achieve its interest without so inferring the adult's constitutional protected rights in reviewing the speech? That is the ultimate question on which the court and I disagree. The majority says that Texas may enforce its statute regardless, because only intermediate scrutiny applies, and that test does not ask whether a state has adopted least. Hang on a second. She might not be wrong here. I disagree. Based on conventional First Amendment rules and the way we have constantly applied them in the very context, the state should be foreclosed from restricting adults' access to protected speech if that is not, in fact, necessary. So I'm gonna read this later, but it does seem no, Hokies, no, she's not saying that. It does seem like what she's saying here, and this is kind of where we're going to end it, is that the majority has not done their job. It seems like what she's saying is, if Texas's law is the least restrictive way and it could achieve its purpose and pass strict scrutiny, then I would be okay with it. But because the majority has not looked at the law under the lens of strict scrutiny, they have erred. They need to look at it under strict scrutiny. That's what, and again, there are 20 more pages of this dissent. So there's more to read about this, and I'll do it. But it does seem like she is claiming that she is dissenting and the other two are dissenting. And let's see if the other two filed concurring dissent. They did not. So they just sided with her dissent. It does seem like what she's arguing is that the court has not reviewed the law as it should. And that's interesting because she's not saying that that box works. No, 0. So here's the deal, okay? If I go to I'm trying to think of let's say that the website abc.com is one of these websites, okay? So if I go to abc.com and it says, please prove that you are over 18 by sending us your driver's license. Well, that accomplishes the goal of making sure that minors cannot view the material. But it impedes my right to anonymously view the material. So it could violate strict scrutiny. But what she is saying, and what it looks like she is saying, is that the court has not done their job by looking at this under strict scrutiny. And that's why I do not agree. It's interesting because it's a sound dissent, and it's the only of the 4 or 5 dissents that or cases they decided in this week. It's the only one that's like, legally sound, in my opinion. Let's see. Encroachment on your rights in the name of limited rights of the minor exposes the adult viewer's prowess, which gives someone an edge over the viewer. Yeah, so I mean that's the thing. Like, does preventing me from looking at something restrict my rights to it? Yeah. Now, look, I agree with the law. I think the industry is terrible. I think it does terrible stuff to children, women, men, minors, adults, grandparents. I think it's terrible across the board. There's a reason that sexual immorality is a sin. But it is a freedom of speech issue. And it's interesting. It's an interesting debate. Huh. I don't know. Like I said, I agree with the law. I'm glad we don't have it. I'm glad we have the law here in South Carolina. I'm glad the major organization, which I'm sure we all know who that is, has pulled out and they don't allow it here to be viewed here in South Carolina. I think it makes it harder to, but I think it makes it more difficult to find it. Yeah, but again, at the end of the day, the best thing to do is to put filters on your home internet. Guys, that's going to be it. We are adjourned. Court is no longer in session. If anyone has any questions, opinions, ideas, debates, please let me know. If there are If there's anything that you want to talk about, anything that you are curious about, let me know. DM me, message me on Twitter, join my Discord, which should be in the link. But if it's not in the link, I will. Where's invite? I will post a link right now. Come on over, join. We have a little bit of fun over there. Not a lot of people talk over there, but we'll see y'all next time. Peace out. Oh, what video am I going to play on my end? We'll go with this. Peace out, everybody.